Hello. Today we're going to be talking about international contracts. I am going to be speaking at Nomad Cruise, which is a cruise of entrepreneurs and business owners who are nomadic and will be traveling from Vancouver, Canada, all the way over to just outside of Tokyo, Japan. And so I'm going to be talking about what it is, the simple things that business owners can do by themselves that you don't need a lawyer for, but that you can make sure are built into your contracts and your agreements, and things to think about that are going to impact your business for the better or for the worse. And so I also created this little cheat sheet, a checklist that we're going to walk through, and I'll show you all how you can download it for free as well. So you can use this video to reference it as you go along in case you want a refresher or bigger explanation. And that's what we're going to do. We're going to break down this checklist of 10 things that business owners should be looking for, either in your conversations, ideally in your agreements, when you're doing cross-border transactions. And when I say cross-border, I mean you are in one country and your customer, are in another, or potentially are likely in another. Yay. So let's even first off start off, right? Like, raise your hand if you have ever had a customer who was upset, things just didn't go the way they wanted, just something for whatever reason. You did everything you were supposed to do, but the customer just, like, something goes wrong, right? Like, right, everybody does. Everybody has this when we do business together. That's how it happens. It's impossible to manage every expectation through every single scenario. And now raise your hand, though, if it was your immediate instinct to sue your customer when they didn't agree with you. Probably not, right? That's not what we do. When in business, we don't just be like, that's it. You don't agree with me. I'm going to sue you. No. We talk through things, right? We're like, this is my perspective. This is your perspective. Hear each other out and hope we come to a resolution. But every now and then, the customer just isn't satisfied, or there isn't a resolution. They won't see things from your perspective. They still think that even though you did everything you could, handled everything in a way that you felt was professional and responsible for your company, that they're just not happy. And so, what do you do in these scenarios? And it's in these scenarios that we often turn to the contract. The contract is where we go for resolution. It's where we go for answers. And it's where we go to say, hey, let's all get back on the same page without even having to deal with the emotions or the stress that's going on inside of us. Let's just see what we came to an agreement on. And that's why today's checklist is going to be really important. Is there certain things that are likely or more probable to sometimes lead to disconnects, discommunication, or things that might be really commonplace for one country, but not for another. And culturally, we're different. And so when we're doing these types of international transactions, that's what today's checklist is about. It's just making sure that we've walked through these 10 simple things that you can handle for your business. Like I said, I went ahead and made a little cheat sheet for everyone. So the link to download this is going to be below. And this is your cross-border agreement checklist. I love it, right? And so right at the top, the very first thing we have is the choice of law. Okay, now what is the choice of law? Right from the beginning, you're in one country, they're in another country. Or even if you're in the United States, you're in one state, they might be in another state. Or you're in Canada and you're in one province, they're in another province. We have to decide which country or which location's laws are going to ultimately decide how we're going to interpret and apply things, because every country, every location, jurisdiction is a little bit different. And so the choice of law section on a contract is the statement in that contract that simply says which country or state's laws are going to be used to interpret, apply, and enforce this agreement, should there ever be questions about that. It's going to clarify which jurisdiction's laws apply should you guys be in different locations. And it's going to be able to create that open communication from the very beginning, before challenges even arise. Because when you have that in your agreement right from the start, you'd be like, hey, we're going to follow the rules of England and Wales. Hey, we're going to follow the rules of France. Hey, we're going to follow the rules of the state of New York. Hey, we're going to follow the rules of Mexico. And it just keeps everybody on the same page. A majority of the time, interactions and business transactions are usually a value exchange, right? Usually payment for either a product or service, but of course, the value exchange can be different. But when it comes to the other layers of that relationship, we're just not always sure. And so that's what the choice of law is going to clarify for us. And so when you're on your contract, you're going to want to list this in your agreement somewhere. And if you're in the United States, the choice of law is by state. Our contract laws are by state. So the state of New York, the state of California, the state of Nevada. If you're in Canada, it's going to be by province. So the laws of the province of Alberta, the laws of the province of Ontario, and so forth. And then if majority of the rest of the world is by country. Definitely Europe by country. I think all of Latin America is by country as well. But just do a quick little search. But for example, if you're in the UK, it's the laws of England and Wales. If you're in France, it's the laws of France, and so on. So just simply making that statement right there clarifies, hey, everybody, no matter where we all are when this transaction happens, these are the rules we're going to follow. And it keeps everybody on the same page from the very, very beginning. Love it, right? So let's look now at the choice of venue, our checklist item number 2, choice of venue. Now, like the choice of law section that we just talked about, right? The choice of law is which country or states or provinces rules are going to apply. We also want to say, in the event something has to happen in person, where are we going to go? For example, if you say, oh, the laws of California, cool, we're following the rules of California. Now, if we have to do something in person, like if we have to go to a magistrate, arbitration, or court, or whatever it is, do we meet in San Francisco, San Diego, LA, Silicon Valley? Every different area is going to have a slightly different approach to things. But most important, one might be easier to get to for certain people than others. So the choice of venue is the statement in your agreement that says if we need to do something in person, the choice of venue is that geographical location. And it's usually by city. It's almost always by city. You're going to pick that city. And that's why we call it venue. This is the venue, right? You're going to go to a concert venue. You're going to go to a sports venue. It's like, this is the exact location we're going to. And so you would say, like, the choice of law in France is maybe your choice of law. Now for venue, you're going to say Calais, Paris, or Nice, right? We talked about California has different locations and so on. So choice of venue is the geographical location everyone's going to have to meet at in the event we need to go to a court, a magistrate, a third party, or do something in person related to the contract interpretation, right? Your business meetings and everything else, you can do that wherever you like. We're just talking about supporting that choice of law part. If we had to do something for that choice of law in person, where specifically do we mean? And choice of venue is really important, even if you are in the same country as your customer. Because, like I said, in France, maybe some of you are in Paris, some of you are in Nice, some of you are in Calais. Like, where does everybody go? Right? Because everyone wants to be whatever's easiest for them. Hey, I'm here, come to me. And they'll be like, no, we're over here, come to us. Now you're going to have everything simplified and easy. Love it. Okay, so we've gotten through the first 2 things on our cross-border agreement checklist. Again, this is available for free download. You can click the link below to get that. Now, moving on to the third item, language. Language, right? English is generally recognized as the language of international business. So most transactions or business meetings and things like that, as long as everybody agrees to English, that's usually the language they're done in. But when it comes to our agreements, sometimes we get to use English and sometimes we don't. So, for example, we just talked about our choice of law, right? Choice of law in France, for example, if your contract needs to be heard in any of the French courts or any of the French ministries, anything like that, it has to be in French. They will not even look at an English written contract. It must be in French. But if you're a French-based company that wants the choice of law in France and you want your venue in France, but you want to do business with somebody in Canada, or, well, Canada sometimes has French, but let's say the United States where almost nobody's going to speak French at the business level, what do? Because an American company is not likely to agree to a French contract. They're not going to understand it. So what we do is you pick what language you want the contract to be written in. And then, if necessary for your customers, you create a dual language contract. A dual language contract is just that, is a contract where one column is in one language and the other column right next to it is the other language. And it's almost a line by line match for each of those two languages. But just like with the choice of law that we talked about, sometimes language doesn't translate literally. It doesn't. We can translate, but literal translations of words, terms of phrases, especially things that are either a legal phrase or a business jargon phrase, there's not a literal language example in the other language. So, to call out which one or which version is going to be the one that controls the one we're going to follow. Hey, cool. We've put the French contract into English for you, put them right next to each other. Beautiful. But in the event there's a conflict, right? The translation isn't literal or doesn't go correctly or could be read more than one way. We are going to use X version. You're going to list which language the version is going to be, right? You want that contract to clearly state, yes, there's an English, yes, there's a French. It is offered in both languages for the convenience of the parties, but in the event of a conflict, the one in English will control, or the one in French will control, and so on. And so, language is one of those other barriers that, even though we can often speak the same language to get the deal done, when it comes to the contract level, right, should things have any disputes or questions that we need that guidance for, we go turn to the contract. We need to know which language version is going to be the one that we're going to go off of. So that's your next one. Now, this next one is probably obvious, but we're going to deep dive a little bit further to let's make sure that it is clear for you, and that is currency. Of course, the currency is which format the payments are going to be made in, and that is because different countries have different exchange rates. Those exchange rates change dramatically. They can change even in a day. Like, you could send the contract over at one price, and by the time the customer signs it, it's actually a different price because of the exchange rate. And this is even more true for contracts over time, especially if there's milestones where payments come in at different times. We end up with not really knowing what the value is going to be 6 months from now, next year, over a 5-year contract. What is the true value? So when it comes to currency, it is advisable to do two key things. One, of course, state which currency you want it in. And don't just state, hey, I want it in dollars, right? More than one country uses dollars. There's the Canadian dollar, the US dollar, the Australian dollar, the Hong Kong dollar. Which dollar do we mean? We want to make that clear from the beginning, especially if both countries use dollars. But even more so if not, because then it really could be open to interpretation based on the regional context. So you want to be very clear. It shall be X amount in US dollars, X amount in Canadian dollars. And we do that. And this is the second part, because you not only want it to be very clear which currency, but you want your customer to have to meet that currency. You don't adapt to your customers' currencies. You make their currency exchange into yours, or that they have to pay you in theirs. And that way, you know you only have to follow one currency for its value. And that's usually the currency you do your books in, or where your business is, you pay your taxes in, and so on, because that's the way you do everything else. Where if you change it to a different currency and you fluctuate to every currency your customers are in, you don't really have a baseline to build your profit margins and your budgets off of. You're going to want this clarified. So, not just dollars, don't forget pesos also is one of those terms that applies to a lot of countries' currencies, even something like neighbors. The Chilean peso versus the Argentinian peso, huge, dramatically different. Just like sometimes we see with the US dollar to the Canadian dollar, right across the border from each other, both extremely stable countries, yet there is fluctuation in that currency. So that's our next one. Payment method. So when we're doing international transactions, payment methods are actually, depending on the type of business you have, which we'll see in a moment, this could be easy or actually more difficult than you realize, especially if you're a cash-based business. traveling with, being a digital nomad myself, I've gone to Rio de Janeiro, and in my household, I was sharing an Airbnb with a lot of my friends. Two of them from the Netherlands, two from Canada, one was Brazilian, one was Polish, and I'm blanking on, oh, and one was Argentinian, right? And then there's me, the American. So of course we're keeping track of household expenses, we're all cooking together and all of these things. And then at the end of the day, I was like, okay, everybody settle up. Who has PayPal? Who has Venmo? What's Venmo? I've never heard of Venmo. Do you guys have Revolut? What the hell is Revolut? I don't know what that is. And it would turn out that maybe one or two of us from our different countries knew what the other one's payment options were. So I had PayPal, I had Venmo, I had Zelle, and I think I had one other. And out of all of those, one of the Canadians had PayPal. And I think one European just happened to do it because he happens to also go to Canada a lot. Nobody else had the same style. So it was almost like money laundering. Of course, it was not. But we had to be like, okay, everybody pay into this person because that person then can translate their currency easily into this payment method simply to pay our groceries for the week, right? Payment method varies greatly. Some countries, credit card is common usage. Other countries, credit cards are not common. And so this becomes difficult when we're doing these cross-border transactions. Larger amounts are usually done by wire, but when it comes to, hey, maybe you're a yoga instructor and you just have those sort of apps on your phone and so on, you want to make sure you have something available to you that your customers have available to them and vice versa. What's convenient for them? If your customers usually have PayPal, it might be worth creating a PayPal account over so that you can get that information and that payment to you instead of always asking everybody to react to what your country has, but at the same time, making sure that it's something you can actually get in your country. So, payment methods, like I said, if they're larger amounts, wire transfers are still ACH, things like that, those are still kind of the commonplace. But because they are bank to bank and they're international, they usually have high fees or they have a minimum threshold. And so if you're just doing like yoga or online courses or coaching, it's possible your total amounts aren't reaching those thresholds or that so much of the money comes out of it, it's not worth it. So looking at your payment method options to your customers, what's convenient for them, but you can also get into your currency and easy for you. And then looking at the price. Is there an exchange rate fee? Is there a transaction fee? Right? Even using credit cards within the United States, there's a 3.5 to 5% transaction fee. If I also have to pay a currency exchange rate on top of that, I'm losing more and more of my profit. And this is really important. So we want to make sure on your contract why this is in your checklist right now is to make sure that it is clear what the payment method options are so that you're not fluctuating to figure it out or scrambling last minute, but neither is your customer. And lastly, clarifying very clearly who is responsible for those currency conversion fees, who is responsible for the transaction fee. And I've seen this where I have PayPal both as a business and as a person. And then but I have made so many friends abroad that I sometimes hire them for their services, like a yoga instructor every now and then, or a Reiki session. And it's like $20 and it's just a one-off thing. But then there's this 20% fee. Who pays it? Am I paying $24 for my Reiki session? Or are you going to only get $16 for the right? So having this stuff clear is really important from the beginning. All right, don't forget this is going to be a free download, this cross-border agreement checklist for you so you can get access to it. Click the link below. It's going to have all 10 things. We're breaking them down right here, right now, of when you're doing an international transaction or international business, like your customers are in a separate country than you, no matter what the amount is, even if it's just a $5 transaction or if it's $5,000, these are all things you're going to want to be mindful of. So that's why we created this quick, easy checklist for all of you. Okay, shipping fees and times. This applies if you have physical products, right? When you have physical products, you got to ship that stuff. And well, international shipping does continue to get better and better and more reliable. It's still not 100% reliable. Less so from the carriers themselves, although sometimes that plays in, but more so from things like custom requirements and their procedures. They are going to have added costs from this. You might have potential delays, like if your box has to be inspected or there's a paperwork error. And then, of course, the need for the accurate documentation. All of these things can affect the delivery time and your profit margins. So I love this example. Is let's say you have you're shipping electronics from the US to Japan. Cool. And you got to face clearance, you got to go through all of that paperwork. Great. And then your customer's like, we never got the delivery. It never seems like it officially made it through customs, but you don't have an answer from customs, right? Because sometimes you can always get clear answers like, did it make it through? Is it still there? What are you doing with it? Why is it delayed? I don't know. And your customer is simply like, look, we never got the delivery. The deadline for delivery was yesterday. It didn't happen. So what do? Right? Are you supposed to rush ship another set tomorrow? Today? Do you get 5 days to recreate the product? Or how do you handle this? Do you get to wait 3 days to see if customs finally lets it go and then it can be delivered? How do you handle this? Who was a response? How long do you wait? How fast are you responsible for getting another shipment out? And two, do you now have to pay rush shipping because the first one didn't make it? Rush ship, not only are you paying shipping costs twice, you're not paying to rush ship it because of something that was out of your control, a delay in customs. And so these things are really important to have clarified in your agreement, right? Who is responsible for any added taxes or fees as it goes through customs, right? Sometimes the paperwork is due when you ship, sometimes it's due upon delivery. Who does this? But also clarifying those timelines and who's responsible for costs if things have to be redone, right? If you sent out 1,000 microphones, you're not only out the cost of rush shipping and doing it again, you're at the cost of another 1,000 microphones. Is this transaction even worth it to you? What does that take? And so making sure we have that clarified in your agreements, because these types of delays, they are foreseeable, right? 80% of the time things will probably be just fine, but there's always those delays, and you don't want to have upset customers who are thinking you're going to rush ship it the very next day, where you're thinking, well, no, I'll just make another batch this week, send it out normal, and you'll get it in about 2 weeks. Who's right? Things you both are. And when we have it clarified in the contract ahead of time, we can make sure everybody's on the same page. So I did just kind of bring it up already, but the next one is duties and taxes, right? This also goes to when you're doing physical products internationally, right? Customs duties or taxes are what the country of destination, the destination country, are going to add or charge for these products entering their borders, right? Sometimes they're called import tariffs, sometimes it's VAT, other types of fees, and things like that. So it's important to know those, but also to know how they're going to affect your profit. And like I said before, when are they due and who is going to pay them? When are they due and who is going to pay them? Your customer might assume it was included in your pricing. You are like, hey, no, that's something that automatically you should handle. All of our other customers have handled it. We want to clarify. We want open communication from the beginning when it comes to duties and taxes. Because it's important for managing your customer expectations, but also for your profit margins and your work process, right? These things are going to affect how you do business. And making sure that it is already clarified in your agreement, if not talked through already with your customer for any of that. All right, we just got done talking about 2 things regarding physical products. Let's look at 2 things regarding intangible products. Okay, intangibles are online courses, when you're giving coaching, when anything that you're not physically shipping, you could do it over the internet, over a webcam. Software is another intangible, data is another intangible, design services are intangibles. all of these things are going to fall into these next two. And the first one is intellectual property ownership. When it comes to international business, sorting out who owns what intellectual property is not as clean cut as it is in your home country. Okay, it can get a little tricky. And that is especially true when one of you is creating or designing something, customizing something even for the other, or you're co collaborating to do something. And it doesn't matter if it's an invention, a logo, or creative works. You want to make sure your contract clearly states who owns any intellectual property, also called IP for short, that is created during this, and that those countries' laws, right? If you go back to the first thing on our checklist, it was choice of law, right? We want to make sure that is part of this, because one word in one country does not literally mean the same word in another. Words like copyright and patent are getting clearer internationally, but they're not exactly just like language translations. They're not exactly the same border across borders. So one that came up for me in my career was work for hire. It's a phrase that in the United States under copyright, when you have a work for hire, anytime you have an employee or you hire a freelancer, it is automatically assumed it is a work for hire unless stated otherwise. So most contracts explicitly state this is a work for hire. And what that means is, hey, the person paying, the company, the employer, the company paying is the one who's going to own 100% of the IP. 100% of it, from design to the creativity, what they could do with it, the licensing, 100% theirs. Where if you use that exact same phrase, work for hire, in a Canadian contract, right? Still English based, right there across the border, does not mean the same thing. Does not mean the same thing. In Canada, it grants a little bit more towards the usage rights, but the owner of the copyright is the creator. The creator still technically owns the copyright, even though the party paying for it can use it. And then, but they still also have moral rights and things like that. Where in the United States, you wouldn't have the moral rights. That belongs to the owner, the purchaser of the product, of the intellectual property. And so something that simple, a work for hire phrase, the use of the word copyright, Canada to United States, has those little nuances that can add up and make a difference. Where if we clarify this in the contract, if we're saying this is who will own the IP, this is how, to the extent they will own it, the other party gets these uses only, or the other party waives everything. We want it to be very, very clear on your contract. Do not assume that the other side understands or that there's not a cultural difference, because there are some inherently built in. So when you're doing anything intangible, even like a logo design or something like that, intellectual property ownership is imperative, because that's who really gets to use it. Not just right now, but 5 years from now, and so on. Do you get to resell it? Do you get to reuse it? Can you rebrand it? Can you share it with others? Or can both parties do this? You want to make sure the intellectual property ownership is clearly stated, whatever you want it to be. You can choose, but make sure it's clearly stated. And that's why we have this on our checklist. Which brings us to the next item on our cross-border transaction checklist: reciprocal respect for intellectual property. Okay. You, of course, know when you own your intellectual property. You know this. But it doesn't always translate across the borders. And so while we've just talked about how your contract is going to clearly outline your intellectual property ownership, it is still equally important to understand how those rights may or may not be respected in the other country. So what's really important here is you want to check what's great, I love about the Paris Convention, I love about the Berne Convention, is that these things helped a bunch of countries. I think the first one was 80 something, the second one was like closer to 200. They all said, hey, we're going to honor and respect. If your intellectual property comes into our borders, we're going to respect it and honor it, right? That is different than saying you filed there and other types of rights, but just merely crossing the border with your stuff, sending your designs to them, sending your courses to them, sending your services to them. You're not just giving that up and saying, well, it's out of the United States now. You don't have your US IP ownership changes over here. So we want to verify in the destination country that they're a signatory to those relevant international treaties before you send it there, right? The Berne Convention provides reciprocity for copyrights. And that's like your literary or artistic works and things like that. Where the Paris Convention is about patents and trademarks. Patents are inventions and ideas, and trademarks are like your logos, word marks, those types of things. So you want to make sure that the country you're sending your stuff to has those basic international treaties signed so that you understand if your IP is even going to be respected on the other side. Because in the beginning, about 20 years ago, there were some major international business countries that weren't signatory to those. And they would take those things and they would take advantage of that. Because you couldn't come and stop them in their country. So they would capitalize on the fact they had access to your intellectual property and use your brand, other things in their country. So as international business has become more popular, there are more signatories. And like I said, it's grown a lot. But you want to make sure that it is going to be, in fact, respected in the other country. So knowing that is why this is on. Click our checklist today. This reciprocal respect for intellectual property. And then, of course, your action step for this is not just making sure that that country is there, but go ahead and just say it in your agreement. Hey, this agreement is subject to the Berne Convention and copyright protection of the United States. This agreement is subject to the Paris Convention and the intellectual property rights of Canada. So you want to make sure that everybody understands the source of the intellectual property and that it needs to be respected across the boundaries of the border. All right. Okay, we've got one more on the checklist, and I threw in a bonus for you. Of course, I threw in a bonus for you. Force majeure. That's how this word is pronounced. Force majeure. Force majeure is situations outside of one's control. Like a natural disaster, right? Big earthquake hits LA. Maybe the roads are down. Maybe the buildings collapsed or aren't safe to enter right now. The infrastructure, maybe they were out of power. A tornado goes through the Midwest. We don't have power for a while. Or a tsunami hits part of Japan. Natural disasters are out of people's control, and they might only affect one of the parties, right? If somebody's in Japan, the other party's in Ohio. Well, the tornado hitting Ohio is going to affect the part of Ohio, but the people in Japan are still going to be like, excuse us, where's our product? Or excuse us, where's payment? Right? The other side is not going to always know what's happening, especially when it comes to infrastructure and things that are taken down. But it's not just natural disasters that can be out of our control. What about worker strikes, public holidays, religious observations, and of course, weather patterns, things like that? They're going to be approached differently in different cultures. And so, what might be foreseeable and avoidable in one country may not be seen that way in another. Right? The idea of a strike in the United States or Canada is seen differently than a strike down in Latin America. One is normal, one is foreseeable based on the timing of the contracts, and the others are not. So, is somebody excused from doing the responsibilities under the contract? That's what force majeure means. Are you excused from doing your responsibilities while the situation is happening? Right? If there's a strike, are you still responsible for getting the product out? If there's a earthquake, are you still responsible for getting the product out? Things like that. And so what we want to do is we want to clarify. We want to clarify things, right? Just the passing away of a big figure like royalty, the Pope, whomever. These big figures are going to impact different cultures differently. And so what that might be an absolute travesty in one country, another country might be like, dude, get over it. I need you at work the next day. So making sure we're on the same page about these things is what force majeure is. And it's for those events that are outside of your control that excuse one party from completing their part of the agreement while that situation is happening. Right? It doesn't excuse it forever, but if the situation lasts forever, right? Like if an earthquake takes out the warehouse and the warehouse needs to be rebuilt, it's going to take 5 years to rebuild it. Does that mean they have 5 years that they don't owe you your product? These types of things that we don't want to sit there and focus on them because they don't happen often. But when they do happen, we want to make sure everyone is on the same page. And when we have the cultural differences across borders, it's really important to make sure that is clarified in your contract. All right, so that's our 10, but we have a bonus. What is our bonus in our free cross-border agreement checklist that you can download using the link below? It is set boundaries in your agreement that protect and support your business model. Your business model, right? An example is limit the uses, the locations, or industries that your product can be used in. Maybe you don't want your product to leave their country. Maybe you don't want that product to leave their city. But what if they're an international company themselves? What if they have an office in France and an office in Brazil? What are you going to do? Putting these types of boundaries can be really helpful because one, that helps you know where your stuff is and making sure that your stuff is only in countries that are going to respect it and so on. But also it can help you get repeat business, right? Oh, now we want to share it with the international office. Cool. Then you can decide, do you want them to pay more for it or not? It's your choice, but the thing is you now have information. So the other example that I listed here is that what they can and cannot do with your product when their use is over, right? All right, you've used our data set. Do you get to keep it? Do you have to delete it? You get to share it? You get to sell it? What are the uses? How do you get them to come back for the next product? Right? It's always cheaper and easier to retain a customer than it is to find a new one. This is what we want to do with these added sections, and that's why it's a bonus for you. So you can think ahead of that with these international configurations and opportunities in your business agreements, making sure that everything is set. All right. Isn't that absolutely amazing? So don't forget to download this checklist. It is available for free below. Just click the link and you get it free from the CEO Legal Coach. And my name is Acacia Thorne. I'm so excited. If you have any questions, go ahead and put them in the comments below or message me at ceolegalcoach.com.